Welcome everyone to our event on the future of cash bail in California. My name is Stephen Raphael. I'm a faculty member at the Goldman School of Public Policy, the faculty director of the Institute for Research on Labor and Employment, and a faculty affiliate at the California Policy Lab. We have a very important topic that we're going to discuss today, and namely that is essentially cash bail, pretrial detention, and how it fits into our criminal justice system and contributes to various issues that are of sort of utmost importance. And in particular, we're going to spend quite a bit of time focusing on a recent state Supreme Court decision regarding a defendant in San Francisco who was held on $600,000 cash bail for a year for a robbery that involved a very small sum. Now, in that decision, the Supreme Court basically ruled that going forward, localities in the state are going to have to take into account people's ability to pay when they're deciding on pretrial decisions for folks who don't pose a risk to society or a flight risk. Those are usually the reasons that justify bail in the first place. And that creates, and also that localities are going to have to look for the least restrictive alternatives that would serve those goals. So we have challenges, and we're looking forward today to a very robust discussion of pretrial detention, of bail, and of options for our different localities and county court systems and jail systems throughout the state. So with that, I'm going to turn it over to Joanna Lako, our research director at the California Policy Lab at Berkeley, and also someone who's done quite a bit of work on the Humphrey decision I've just mentioned and on criminal justice more generally. So welcome, Joanna.
Thank you, Steve. Before I introduce the panel, I'd like to say just a quick word about the California Policy Lab. The lab was founded at UC Berkeley and UCLA in 2017. We pair experts from the University of California with policymakers to address the state's most urgent social issues, including homelessness, poverty, criminal justice, and education inequality. A few of our current projects in the criminal justice space include studies of diversion programs, juvenile justice interventions, pre-arraignment representation, record clearance and sentencing reform, and analyses of race equity throughout the system. And to do this, we partner with local district attorneys' offices, sheriffs, and probation departments, and we work with state agencies. All of this wouldn't be possible without our funders, including Arnold Ventures, the James Irvine Foundation, the UC Office of the President, the Clean Slate Initiative, the Abdul Latif Jameel Poverty Action Lab, and the Bilo Chaffone Foundation. But today we have a fantastic panel, and I'm going to provide brief introductions and then see full bios in the chat, and we'll get straight to questions. First, we have Marshall Kine. Marshall is an assistant district attorney for the San Francisco District Attorney's Office. He has been assigned to almost every trial unit in the office and has managed the domestic violence unit, the mental health unit, and the sexual assault unit. Marshall currently serves as the chief of the criminal division. Next, we have Incha Rahman. She is the vice president of advocacy and partnerships at the Vera Institute of Justice. In this role, she incubates new work in the areas of prosecutorial reform, bail, and decarceration, with a focus on developing advocacy-related strategies and accountability. With a background as a public defender, Incha is a nationally recognized expert on bail. We next have Sandra Susan Smith, who's the Daniel and Florence Guggenheim Professor of Criminal Justice and Faculty Director of the Program in Criminal Justice Policy and Management at Harvard University. She conducts research on the front end of criminals in several other areas, including the short and long-term consequences of pretrial detention and diversion. And racial equity and its root causes are core areas of Sandra's research. So to get started, let's define some terms. Marshall, can you tell us what the pretrial period is in criminal justice case processing?
Yes, the pretrial period generally refers to the period of time from when a defendant is arraigned, their appointed counsel, charges are announced, and the person is instructed on their rights to the time when the case is finally adjudicated, usually either by way of a plea dismissal or a trial verdict And in this period of time, it's specifically important to recognize that guilt hasn't been established, the presumption of innocence applies, and obviously it's not an appropriate time to punish somebody by keeping them incarcerated. So the focus really of this period is determining what is the risks to public safety, safety of victims, as well as flight risks.
Great, thank you. Insha, I'm going to turn to you. Why is focusing reform on the pretrial period so important?
So as Marshall said, the pretrial period is what happens until a case is resolved, either in a dismissal, a plea, or a verdict. But the pretrial period is one of, I would say, the most important but sort of unfocused upon parts of a criminal legal case. Everybody talks about trial, but the truth is the vast majority of cases don't go to trial. And what determines whether somebody has the ability to actually fight the charges against them in a fair way is whether they're incarcerated or released pretrial. And I know this from my experience as a public defender. I worked in the Bronx as a public defender for almost 6 years before coming to Vera to move into this role of doing more policy and research and advocacy around bail reform. And what I saw day in and day out in the Bronx is I would watch judges set bail on the people I represented, $500, $1,000, $5,000. And every single time I wondered, did the judge intend for my client to be released and they thought they could make $500, or did they intend for this person to be incarcerated? And there are many, many problems with money bail, but one of the fundamental problems is it obscures the intent of the pretrial decision. And judges might think that people can make $250 bail or $500 bail, but the Federal Reserve did a study a few years ago and found that over 40% of Americans don't have $400 to cover an emergency. So when the average bail in this country on a felony charge is $10,000, you can understand that most people will remain incarcerated pretrial. And the research has shown the impacts of that on people's lives. People who are incarcerated pretrial lose their jobs, lose their housing, lose any modicum of stability. And we know what impact that has. Research has shown that the fact of pretrial detention, even for 2 or 3 days for people, results in a greater likelihood of future contact with the criminal legal system. They will be arrested again, in part because the experience of incarceration is so destabilizing. So that's the impact of incarceration on a person's life. Research also tells us that the impact of pretrial detention and incarceration has outcomes on the criminal legal case itself. People who are incarcerated pretrial versus people who are similarly situated, same charges, same past history with the criminal legal system, past convictions. If they are incarcerated, they are 14 percentage points more likely to be convicted of a crime and more likely to have a jail or prison sentence attached than somebody who is free to fight the charges in their case. So I know this deeply from just personal experience, as well as what the research tells us and what we've seen across the country when we rely on incarceration in the way that we do day in and day out in the pretrial period in this country.
Thank you. Sandra, I'm hoping you can tell us about the potential effects of bail reform on individuals involved in the justice system.
There you go. Thank you, Joanna. So in many ways, I think when we think about the potential effects of bail reform, it is thinking about all of the issues that Insha just raised. And these are some that I wanted to be able to share as well. So there might be a little bit of repetition, but I think the point is important to make, and probably many times. Although it's difficult for any of us to imagine the damage that just a few days in jail can do to the life of an individual and the communities to which they belong, recent research indicates that spending any more than 1 day, it can happen in just 1 day, and pretrial detention can have devastating consequences. Here again, I'm going to repeat a number of the points that Insha made, but I think that these are important. First, pretrial detention increases the likelihood of conviction on current charges. For instance, analyzing the consequences of money bail, a proxy for pretrial detention. Gupta, Hansman, and Frenchman, these are some authors, economists, find that it leads to a 12 percentage point increase in the likelihood of conviction. All things else equal, being detained versus not leads to a greater likelihood of being convicted. It also leads to harsher sentences. You're more likely to be sentenced to incarceration, and those sentences are much more likely to, they're going to be longer. Individuals' psychological and physical well-being is also negatively affected by pretrial detention. A large proportion of incarcerated people have some form of prior trauma. Pretrial detention both creates new traumas, and the jail experience itself can be re-traumatizing, leading to post-traumatic stress reactions during incarceration and once released. Indeed, the prevalence of psychiatric symptoms, mood and anxiety disorders, comorbidity have been found to be twice as high among formerly incarcerated people. Importantly, the mental health issues and emotional distress that individuals develop during incarceration can also lead to future misconduct and can prompt individuals to harm themselves. We should keep in mind that rates of suicide among pretrial detainees are quite high. A large and growing body of research also indicates that pretrial detention can do harm to individuals' physical well-being. It doesn't, as the recent events have again illustrated, jails are breeding grounds for spread of infectious diseases, and it doesn't take long for that spread to happen, infection to happen. Violence is also a mainstay. People take that trauma with them. Pretrial detention has been found to significantly reduce employment, wages, and annual earnings. One of a set of my colleagues here at the Harvard Kennedy School found that 2 years later, people who were held pretrial were less likely to have income, that means no job, to be employed in the formal labor sector, to file a tax return, and to receive EITC benefits than those who were released. So they look almost exactly the same, and one is very much integrated into the social safety net system, but the other has been marginalized. Pretrial detention increases the burden of criminal justice financial obligations, often shared with family members and friends. In my own study, based on a sample of low-level nonviolent offenders, people who've been convicted of crime in San Francisco, showed that roughly a third reported that debt was a major issue for them because of their pretrial experience. And much of that was related to the fact that they bailed themselves out. They had to. Many did so because they didn't want to miss work and they didn't want to lose their jobs, even when these jobs often didn't pay very much. And a number of people also did so because the conditions of confinement were so awful, they did not know if or how well they would survive. Once released, individuals who had been detained were more likely to be arrested again for new criminal activity. This is a point that Inshna also made. And then we should talk about the costs versus benefits to the broader society. Based on tentative calculations, my colleagues estimate that the total net benefit of pretrial release, letting people go, especially for low-level nonviolent offenses, it saves society anywhere between $55,000 and $100,000 per defendant. That's the benefit of letting them go. Intuitively, pretrial release on the margin increases social welfare because of the significant long-term costs associated with criminal conviction. And it also has impacts on the criminogenic effect is also something what we want to take into consideration. So the whole host of burdens, harms done by holding people pretrial when we could release them and have much better outcomes. And it's also important to place what we have learned about pretrial detention's harms in the broader context of the harms that are done by the criminal legal system, generally speaking. So we're talking about pretrial detention now. Recently, we've also learned about the downstream negative consequences associated with prosecuting nonviolent low-level offenses. Very recent study has found that for the marginal defendant, prosecution of such cases significantly increases the likelihood of a new criminal complaint, 1 to 2, even 3 or 4 years out. So if we were just to leave them alone and let them go, they would likely not have further contact with the criminal legal system. We also have learned that aggressive policing has been shown to erode the mental health and well-being of Black and Latinos. Especially those who live in communities where aggressive policing is the norm. In such communities, aggressive policing is also known to negatively impact adolescents' educational attainment and academic achievement, as well as their emotional and psychological health and well-being. I'll end by saying that the potential effects of bail reform on individuals are huge. So imagine if we didn't hold as many people, all of what I've just described and all of what Inshna has just said, we would be relieving people of those harms, and consider how much improved society would be if we didn't do that. So bail reform would be a huge bonus to any community that engaged in it. And we've been seeing these outcomes in states that have actually implemented these reforms. Oh, and their apologies for going so long.
No, thank you. Great. So I think a lot of people are hoping that the Humphrey decision that Steve described earlier is one step towards bail reform in California. So following the Humphrey decision, all California courts must consider the arrestee's ability to pay and whether less restrictive conditions of release can meet the state's interests. So Marshall, what does the decision mean for the courts and what is left unclear by the decision?
Well, the decision is a sea change for the courts. Courts historically have relied on bail schedules set by the county judges, and our high court has now determined that that's unconstitutional, that there has to be now an individualized assessment and determination as to the ability to pay, and just arbitrarily setting an amount that is beyond a person's ability to pay is in effect a detention. So the analysis has to go much deeper. And what that means for the courts across the state is that there's got to be a lot more investment in terms of the time that the court will take in conducting arraignments. Arraignments historically have been a relatively fast process. Court can rely on a bail schedule based on the charges, and now a court will have to undertake the responsibility of determining the individual's ability to pay if the court is not releasing the person on non-monetary conditions. And if the court decides to deny non-monetary conditions of release, it will have to make certain findings and determinations that the person poses such a risk to public safety, safety of the victim, risk of failing to appear, that it justifies either going beyond the person's ability to pay or going directly to a detention without bail. There were some aspects of the Humphrey decision that leave some questions unresolved in our minds, at least. That what are the limits to no bail detention? We raised in a letter to the Supreme Court a request to resolve the difference between an interplay between California Constitution Article 1, Section 12, and Section 28, both of which address bail. Section 12 expressly says that an individual shall be released on bail, and Section 28 says may be released on bail. Section 12 provides for some very specific categories in which bail can be denied in capital cases: violent offenses, felony sexual assaults, and threats where there is a substantial risk of harm to the public or an individual if the person's released. And 28 is much more broader, just looking at factors of public safety, individual safety of victims, and risk of failure to appear. Humphrey doesn't expressly address whether or not Section 28 provides a broader basis to detain without bail. So it still does rely on setting bail beyond the individual's ability to pay after that individualized analysis. And the other questions left in our minds is, what is the definition of public safety? Is that merely the safety of individuals from physical harm? Does that include the risks to property crimes? As we see, oftentimes we have many nonviolent offenders, but they're very prolific in property crimes. At what point, does that constitute public safety? Humphrey doesn't expressly address validated actuarial risk assessments and the role that that may play in the analysis. We have another case that controls in San Francisco by a federal court, Buffin v. San Francisco, and in that case, it does place some weight on the actuarial's assessment. In San Francisco, we use the Arno Foundation's public safety risk assessment. The other things that we're working through is how do we determine an individual's ability to pay? Who bears the burden of proving that? Is that an inquiry just based on representations of counsel in court? Do we have to go into financial records? What does that mean for the setting of the amount? Is that amount, if the court is going to set it beyond a person's ability to pay, at what level is that considered? Is it twice the person's ability to pay? Is it such a large amount that there's no possibility that a person would get out of custody, and that amount can vary greatly. If somebody has absolutely no assets whatsoever, $1,000 may keep them in custody, as opposed to somebody with considerable wealth. And does that ability to pay take into consideration the ability to pay the full bail amount or the amount that would be necessary to secure a bond for their release? And lastly, it's a little unclear as to whether or not this requires all the courts around the state to retroactively look through everybody that's in custody to proactively go through this assessment. We don't have that problem in San Francisco because we have been pretty much following what Humphrey prescribes as a matter of policy for a few years now. But I would imagine that there may at one point be some challenges to all the individuals that are currently in custody that have not been reanalyzed through this lens.
Thank you. Cha, turning to you, do other states have similar laws, and what can we learn from them potentially about some of the questions that Marshall raised?
The language of Humphrey is groundbreaking. It is exciting. It reinforces where we know we need to go in this country, which is wealth-based detention should be unconstitutional. Increasingly, courts have found across the country that it is. But the problem isn't the language of the law. Across the country, most states have actually quite good laws on the books about considering financial circumstances and the use of money bail. The problem each and every time is culture and the practitioners who put these laws into effect. And so let me talk a little bit about ability to pay specifically, because that's what Humphrey has shown a spotlight on. And I'll talk about a project that my organization, the Vera Institute of Justice, ran in 2 arraignment courts, which is where bail hearings happen in New York City, in the Bronx, and Queens. And I want to start by saying, I fully believe that we need to end money bail. Money bail is a relic. It's the origin was that the thought was we needed a financial stake in your case in order to incentivize you to come back to court. But time and time again, research and experience has shown in Washington, D.C., New Jersey, New York City, Harris County, Texas, and a number of other Kentucky, a number of other places across the country, we don't need money bail. People come back to court. So I hope money bail goes. But to the extent that hundreds of courtrooms across the country are using money bail day in, day out, how do we actually give meaning and teeth to this idea of ability to pay? And so that's what we were after when we launched this pilot project in the courts. And what we did was first and foremost train the judges and the defense attorneys on the different forms of bail that are available under New York state law. And these forms of bail, partially secured bonds, which are judges can set a bail amount and the person has to put up no more than 10%. of that amount to the court. And so long as they make all of their court dates, they get that money back at the end of the case. It's called deposit bonds in many other places. And unsecured bonds, which is basically an IOU. You don't have to put up any money. You're only on the hook for that full amount if you don't come back to court. And actually before the 1900s, pretty much every bail that was set in this country, by and large, was in fact an unsecured bond. It was only with the advent of the bail bond industry that we really saw the use of money bail as we know it today. And so we worked with the judges to get them to use these different forms of bail and to hear on the record, what could a person afford? And so if defense attorneys flagged a case for us and said, hey, I think the judge is going to set bail on this case, we would actually go meet with their client and ask a series of 30 questions. And we developed these questions in partnership with a social science research lab at Duke University of how do you actually ask people questions to get at their financial circumstances. And so the questions basically took in, what does this person have in terms of assets? What are their monthly financial obligations like rent, childcare, transportation? And then if there was a net amount left over, what percentage of that could go towards paying bail without causing undue hardship? And we would literally put that amount on the record. And in 60% of the cases that we evaluated, people had no ability to pay. And just even putting that on the record and saying, Judge, we asked 30 questions. And after that, this person actually has zero ability to pay. In fact, they're in the red each month, meant something because it was a meaningful inquiry into this individual and their financial circumstances. And when people did have some ability to pay, what we found is that the average ability to pay was $208. That's it. And in the Bronx, the sort of going rate for where bail starts is about $500. And I would say in my years of practicing and sort of going around the country and watching bail hearings, that's actually relatively low. Most people can't make that. That was essentially what our intervention, our pilot showed us. And so we got on the record and we literally said things like, this person can afford $17 bail. This person can afford $100 partially secured bond. They have $10 in their pocket right now. And what was fascinating is in 30% of the cases, and mind you, these were cases where defense attorneys had already said, I'm pretty sure bail is going to get set. And defense attorneys know because they practice in that courtroom day in, day out. They know those judges, they know sort of judges' habits and tendencies. In 30% of the cases, after hearing this information, judges just released people. And I think that's significant because basically it forced judges to confront, if I set a bail amount that's higher than what I just heard, that is a de facto detention order. And I actually I'm okay with this person being released. I think hearing a specific number, what somebody can afford to pay, actually can change judges' behavior to really confront the decision of what am I doing by setting bail and hopefully go in the direction that they should go in, which is to not set bail, to release people. And then in the other about 70% of cases where judges continue to set bail, we actually pulled historical data on bail setting and saw that at least hearing what somebody could afford had judges set bail at lower than they would have otherwise set historically. And so we ran this project in the courts for about 18 months. In the middle of that time, the law in New York State changed, where ability to pay became an explicit part of what is required for the small number of cases for which money bail is still allowed. And we think it was important and impactful. And we know that the legislature heard about this project and actually wrote into the bail statute in New York that if judges set a money bail, they have to set a partially secured or an unsecured option. For a family, paying 10% to the court as opposed to the bail bondsman means they get that money back at the end of the day, which is a really important way to sort of get around the bail bond industry and kill the bail bond industry without actually killing them outright, because we simply didn't have the political power to write them out of the statute. So that's the best example I know of where we've actually put into practice ability to pay, but I would say it's imperfect. A lot of judges just ignored it. They thought it was ridiculous to say somebody can afford $17 bail. And yet that's the sort of cultural shift that we need to engage in to make it sort of relentless in the courts. This is what people can actually afford. And so beyond that, in settlement agreements that have happened across the country where jurisdictions have been sued for constitutional violations of how they set bail, usually what we see are indigency affidavits that people are just found to be, per se, indigent if they qualify for a public defender or if they are on public assistance. And I would caution going in that direction, especially with Humphrey, because what we have found in our experiences, if judges are like, yeah, you are also indigent, you are also indigent, it becomes the same assembly line that we see in court. And then judges don't take the chance to sort of think for this case individually, because I heard something more about this person, I might actually consider this case differently.
Thank you. So I think in California, a lot of us are really wondering what's going to happen when Humphrey goes into effect. And as Marshall noted, Humphrey has been in effect in San Francisco County since January 2018. So we did a quick analysis of data to look at what happened in San Francisco pre and post January of 2018. And what we found in quick summary is that following Humphrey, there was a small decline in the share of filed cases that were detained for the full trial period. So a small decline in detention and a decline in the share of filed cases that were released on bail. So definitely there was a rethinking of setting bail that was happening. We also found an increase in the share of filed cases released to intensive supervision. So that's electronic monitoring or supervision that's similar to probation, prior to the determination of guilt, or both at the same time. And we also found that Black and white individuals experienced the largest decrease in the likelihood of detention following Humphrey. And the share of Hispanic individuals detained stayed pretty constant before and after Humphrey. And that was the group that had the lowest detention rates in general. So those are just some quick takeaways, some things we might think about as other counties start implementing Humphrey. And I'm interested in hearing from the panel what advice you might give to California counties as they begin to adhere to Humphrey, given what Incha has shared based on experiences in other states and based on the experience of San Francisco. So Sandra, can I look to you first?
Sure. I think that California counties should take very seriously the lessons that have been learned in other states and municipalities about the benefits of bail reform and reductions in pretrial detention without major threats to public safety or harms to individuals and their families. And she mentioned appearing at court. The other issue that seems to drive decision making is this fear that they will release someone who will then go off and rape and murder. But what we're finding across multiple jurisdictions is that releasing people on bail, releasing people or reforming bail and then releasing people without having to put up money for bail doesn't lead to any kind of threat in public safety. There are no increases in crime. So for instance, New Jersey, New York, and Yakima County in Washington have all experienced declines in pretrial population on the order of 45% with no negative public safety effect. Washington, D.C. since 1992 has been releasing 90% of arrestees without a financial bond with no negative public safety effect. Philadelphia has followed Washington's lead to some extent, at least, and they also now release 90% of people at least facing misdemeanor charges without bail, again, with no negative public safety effect. I'm not quite sure what the rates are with regards to failure to appear, but my sense too is that they don't differ that much from what you would expect for people who are being held or released on bail. So to the extent that we are not experiencing any major increases in threats to public safety, and it corresponds with huge harms, economic, social, psychological, penal, why not consider bail reform that allows people to be released without having to put up a financial bond. So that's what I would recommend them doing, taking seriously the lessons that we're learning in other contexts and following them.
Thank you. Incha, you want to weigh in?
Sure, I agree with all of that. One thing I will say is that we do know what the numbers are where we have good failure to appear or court appearance. data, which isn't everywhere. Court records are notoriously bad across the country, but New York City for decades has been collecting court appearance rates. And what we found is people who are just released on their own recognizance come back to court 87% of the time in New York City. And the single most important intervention that New York City has had in place for, again, decades is court reminders, just phone calls and text messages, which are cheap, easy to implement. And the impact is just, it's remarkable, literally at least 10 percentage points higher in terms of court appearance rates for every jurisdiction we've studied that has court notification. For people who are released on bail in New York City, the court appearance rate is 91%, so comparable to 87% for sure. And for people who are released under supervision with, not under monetary conditions, but have some amount of supervision and supports during the pretrial period, the court appearance rate is 92%. So it tells us that actually you just don't need money bail to get people to show up to court. And money is a terrible predictor of whether somebody is a danger to the community or to a person. It just simply has no bearing. And so I couldn't agree more with Dr. Smith that getting rid of money bail is the most important thing we can do. In terms of California, there's a bill, and somebody mentioned this in the Q&A, that's pending right now, Senate Bill 262. Senator Hertzberg is the lead sponsor, along with Senator Skinner. And it's a bill that will essentially codify a measure that the Judicial Council in California passed at the beginning of the pandemic, or Emergency Release 4, which basically requires that for a lot of misdemeanor and even some nonviolent felony offenses, that people are released on $0 bail. Essentially, they don't have to put up any money. I think that that is actually going to be more profoundly impactful when it comes to pretrial detention than Humphrey itself, because it is immediate, it is clear, and it takes away what is the biggest challenge to any kind of bail reform, which is discretion, prosecutorial discretion and judicial discretion, which culture eats policy for breakfast every single day. So I would say that that's where my hope is for California, what I think will have the most impact. But when it comes to actually implementing Humphrey, and to Marshall's point about the culture change that's going to have to happen in the courts, and the practice changes of taking time to actually assess people's ability to pay. So often the pushback we're going to get is we can't afford to do that. We can't afford to delay arraignment. Well, we actually can't afford the pretrial detention and incarceration system we have. It is every single time more expensive than what it would cost to set up pretrial services across the state to actually do the kind of due process and smart work we need to do before we even make the bail decision. So that's the other piece that the legislature and the Judicial Council should invest in as Humphrey is being rolled out, because it is the thing that will make the most difference.
Can I also add, for other counties, I certainly agree with everything that's been said. In this particular county, we don't favor money bail. In fact, we, even before Humphrey, had long started a policy of not requesting and utilizing money bail as a proxy for detention, understanding and believing in inequities that creates in our system, and doesn't make anybody safer, because the wealthy can bail out even if they're violent and dangerous, and the poor stay in whenever, it could be a minimal amount on a nonviolent offense. So, with that, I certainly believe, I think across the state, there needs to be a culture change. But in terms of, what the counties probably need to be doing right now is investing in the pretrial services and pretrial programs, because I think in the long run, that has really helped our county, that we had that infrastructure in place already, and it has evolved and become far more robust. It gives the court a lot more tools to provide for the supervision and monitoring that gives the court the comfort and assurances that will return folks to court safely without doing more harm. And in San Francisco, we're blessed with great pretrial services, a sheriff's that is very proactive with electronic monitoring and home detention. We also have a lot of mental health services and residential treatment programs. And that gives us some options, because many times, many of our individuals that come through the system have serious mental health issues and languishing in custody. does more harm, not just to individuals, but to public safety, because when they get out untreated, they're more dangerous. Whereas we have the option in San Francisco to refer them to residential treatment programs. We do what's a warm handoff, where they're delivered to the program and their mental health issues are addressed immediately. So in the long run, I also agree that it's a huge cost savings for the county because keeping somebody in custody is still going to be far more expensive than investing in the pretrial services, the residential treatment programs, and electronic monitoring.
Thank you. So taking a step back, I'm interested in talking about what the implications of bail reform like Humphrey or like SB 262 are for race equity in the justice system. And I'd love to hear from each of you. So if anyone wants to go first, we'll open it up.
So how about I go? So I think, although it makes intuitive sense, that bail reform, generally speaking, might help to reduce racial disparities, since those who are held on bail and in jails pre-trial are disproportionately Black and Latino. I'm not sure that we should take that for granted, because this often doesn't happen when we put forward reforms that we think are fairly progressive and we expect it to have a major effect on disparities. It doesn't work always. I'll give an example in New York, and then I'll come back to this particular issue in New York and marijuana possession. Decriminalization of marijuana possession in New York occurred a couple of years ago across all three major geographic areas of the state. Blacks and Latinos consistently had higher rates of arrest for misdemeanor marijuana possession. They put into place a shift in how law enforcement dealt with this issue. So they were no longer supposed to arrest people if they had marijuana unless it was open. After this decision not to arrest, we saw the rates of people who were being arrested for marijuana possession plummet. But we also then saw huge racial disparities emerge, massive. They were 3 times larger in New York City, and outside of the city, they were between 12 and 20 times larger. So even when we're implementing policies that we think will have this, a major effect, and to some extent it did. We did reduce the absolute numbers of Blacks and Latinos that we were bringing into the system because of marijuana. The process also led to massive inequality. So let's get back to bail reform. We see a very similar impact happening in New Jersey, for instance. There were substantial reductions in the number of people who were held pre-trial, but in a system that disproportionately incarcerates Blacks and Latinos, racial disparities persisted. Despite the fact that the New Jersey incarcerated 3,000 fewer Black people because of reforms, 1,500 fewer white people because of reforms, and 1,300 fewer Latinos, Black men still comprise well over 50% of the state's jail population. So they did work, right? And I'm really thrilled for the 3,000, 1,500, and 1,300 people who did not have to serve that time. But it effectively did not impact racial disparities at all. And so I think even as we put forward these policies, et cetera, that we think should have this impact, it often doesn't. And we need to go deeper to figure out what else is going on that might be driving the disparities that we see. And I think that takes, it means taking a look at things like bias. And the kinds of decisions that court authorities are making, but there are a whole other set of factors that we should be considering.
Yeah, I would agree with Dr. Smith. It's a step in the right direction. There's still a lot of work to be done. It helps with reducing wealth-based inequities to the extent that race and wealth have some correlation. It might offer some improvements there, but there are a lot of other aspects of the criminal justice system that still need to be reevaluated.
I'll chime in to say, we have not seen a place where we have done bail reform and decarcerated, have fewer people behind bars and actually make racial disparity better. We just haven't seen it yet. So in New York, likewise, we had decarceration of over 1/3 of the jails across the state when bail reform was passed in 2020, and racial disparities actually got worse. And we saw that in New Jersey as well, where the jail population before bail reform in New Jersey was 54% Black. After bail reform, 55% Black. We're just really struggling with this question. And so when folks ask, well, what do we do about racial disparities? I think the only answer is we have to take away discretion. And I know that that's a hard thing to hear. There are prosecutors, there are judges, there are court practitioners who are listening to this, but it's not intentional, the racial bias. It is deep, it is implicit, it is in each and every one of us, and it's baked into the criminal legal process, from arrest to the decision to charge to the bail decision, which we're talking about. So it's all just compounded. And until we take away discretion to say there are certain charges in certain cases where we're simply not going to allow for detention, either through money bail or through some other means, I don't think we're going to get at racial disparities. And I know that that's a hard sort of blunt thing to say, but I truly think that's the only way we get at the huge, huge disparities we continue to see, even in places that have decarcerated and decarcerated well.
Amen.
Great, thank you so much. There was one question that came in the chat, and I'm wondering if Marshall, you could address it. The question is, in San Francisco, what is the role of the Sheriff's Department in the pretrial release process?
Yeah, so our Sheriff's Department is responsible for certain conditions like electronic monitoring and home detention. They also have our pretrial services annexed to the Sheriff's Department. It's a separate entity or agency, but it is under the umbrella of the Sheriff's Department. So that allows for a free flow exchange of information. The Sheriff's is able to use its access to the criminal justice histories so that our pretrial services can produce the pretrial risk assessments for the courts. So they're interrelated and intertied with our pretrial services, but they're primarily responsible for the conditions of electronic monitoring and home detention.
Thank you. Another question touched on the accountability and how kind of how Humphrey's implementation will be observed in throughout the counties in California, and how counties will be held accountable to comply with Humphrey. I'll let anyone speak up if they have thoughts on how that might work.
I can jump in to say, I think what should be uncontroversial to all of us is data collection that is consistent and transparent. And there isn't good data across California about what the courts are doing. And so in the wake of Humphrey, there should be a requirement that each county post monthly. New Jersey does this and they do it really well. Post monthly, bail decisions, how many people are released, how many people are held, more information about the bail decision itself, and information about what each county is doing to actually get at the ideals behind Humphrey and calculating ability to pay. That's the only way we'll know if it's being followed or not, if it's working or not in places that say that they are following Humphrey. And sunlight is a great disinfectant. It helps us make good and sound policy.
Great, thank you. I'm happy to let folks have time to have any final thoughts if they do. I'm not seeing other questions in the chat at the moment, but if people have additional questions, give a minute.
Joanna, there's some questions in the Q&A. That helps.
Great. There's a question. Says, is there any evidence of changes in arrest and police practices following bail reform in San Francisco, following Humphrey implementation? The MDRC evaluation of New Jersey found reductions in arrest, which raises questions about enforcement policies. I could say that we haven't done that study, but I will turn it over to Marshall to see if he can answer.
Yeah, I mean, we track the statistics in our county. What's a little hard to attribute necessarily to Humphrey, particularly this past year, is because everything due to COVID has shifted a lot of our criminal statistics. I don't, in discussions with the police department, I have not heard of any specific changes in their arrest and police practices. We do have operations in conjunction with the Buffin decision, which requires that the police department provide at least the investigative report much more early to the court so that the court can meet the Buffin requirement of reviewing non-violent, non-serious arrests within 18 hours. So that required a significant change in practices. But aside from that, I'm unaware that the police department has changed any particular arrest practices.
Thank you. Great. There's another question about what are the prospects for SB 262. I know we mentioned it, referred to it earlier, but if anyone has thoughts about how likely it is to go into effect.
I had written back in the chat, and I'll just say it out loud for folks. I think it has a chance. It passed SB 262, passed Senate Appropriations Committee. It's now been referred to the House Public Safety Committee. There is opposition from the bail bond industry, which is no big surprise. And then also opposition from various pockets of law enforcement. So the bill as it currently stands is actually less robust than what the Judicial Council passed last year during COVID. And mind you, when the Judicial Council's order went into effect, we saw jail populations across California decline by about 20%, 18.5% exactly. And then a number of counties stayed with the emergency order while others rolled it back when the Judicial Council lifted the overall order statewide just a couple of months after it went into effect. So that's what we can anticipate the impact will be on jail population statewide if it does in fact move forward. It's not a done deal, but given that it's Senator Hertzberg, who is a huge champion of these issues, I think it has a good chance of passage.
Great, thank you. I want to thank all of the panelists for your insights today. I know I learned a lot and I think about this all the time. So I'm really grateful for your participation, speaking with us. And I'm so glad that all of you who joined us and were listening out there were able to join us and learn as well. I'd like to take a moment to provide contact information for the California Policy Lab for those of you who'd like to learn more about us or interested in exploring how you can get involved in our work. You can sign up to receive updates about new research and see policy briefs, get updates about events like this where we bring in experts on different topics and learn from them. So if you'd like to support that type of policy research, you can contact us at support@capolicylab.org, and please sign up for our listserv and get all of the updates about what's going on in policy throughout California. So once again, thank you so much to our panelists. Thank you to those who participated, and we look forward to seeing a lot of progress on bail reform going forward.